We're back for the Sarah Boone sidebars, and this is going to be part 2 out of part 3. This is a 3-part series, and guys, part 3 gets really unhinged, so definitely check out part 3 when it comes out, which should be sometime this week. So, where we are at right now, Mr. Owens is going to have a lot of issues with one of the expert testimonies of the state, and if you guys remember, it was Dr. Warner. Now, remember, Dr. Warner was supposed to reach out to Mr. Owens if she formulated any new opinions, and the court did find that there was a discovery issue that Dr. Warner didn't do this, and she was testifying about it. So, as a remedy, they allowed Dr. Warner to be deposition in court, live by Mr. Was it again? Mr. Owens. Yes, Mr. Owens. Now, this was outside of the jury presence. So we get to see the sidebar, basically what was happening in the discussion between Mr. Owens, his frustration with the state, and some back and forth. But honestly, I think we got to see a lot of that in camera as well. So enjoy part 2 of the sidebars. And again, part 3 is pretty unhinged. Y'all need to watch that. All right, y'all. We are at page 1,700 out of 2,500. We are moving along. All right, where are we at now? Mr. Owens, Mr. Lane. Oh, is this Billy Lane? Billy Lane. Billy Lane is the investigator. Okay, Billy Lane. I don't know what's happening. Okay. The court. Just 1 second, sir. I'm waiting for Mr. Owens to return. Mr. Henderson. Judge, may we approach for a moment? The court. Without Mr. Owens? Mr. Henderson. Yes, Your Honor. The court. Sure. Mr. Owens. Can we approach the bench? Oh, he is here after all. Yes, sir. Mr. Henderson asked. At the bench. The court. Hang on. We'll wait for the rest of your team. Mr. Owens. I just called. Can I do this first? Yes, sir. I just called Dr. Harper. She didn't answer the phone, but sometimes I communicate with her by text. I'm just going to text her. I don't know. She's, they made her last night. The hotel room, the Hilton is split into 2 different types of the room, like a home to home and then the Hilton. They put her on the more expensive one. Ooh, who put her on the more expensive one? Oh no, JSC doesn't cover that. Oh no, who paid for it then? They put her in the expensive room. JAC doesn't cover that, so she had to move this morning to the other one. So I don't know what the status is, but I'm going to text her. The court, just text her and tell her to be here at 1:30. Mr. Anderson? Yes, sir. Damn, I wonder if Mr. Owens had to cover the cost of her staying at the more expensive one, or if she had to pay for it. How did they deal with that? Mr. Anderson? Yes, sir. Mr. Anderson? Yes, Judge, I know you stated that 3.6F. I'm also going to be setting 3.6G. Okay, so 3.6F was justifiable use of deadly force. Is 3.6G justifiable use of non-deadly force? I think. 3.6G. Florida. It is justifiable use of non-deadly force. Haha. Okay, I remembered correctly. All right. So they're going to put that instruction in. Whatever instruction you want, please send, says the court. Next. Is this going to be... Oh, I think, is this the neighbor that testifies? Did she ever act uppity? Mr. J, objection, relevance, overruled. Mr. Beck, did she ever treat you in an uppity manner? What do you mean, sir? Did she ever look down on you as a person? Oh, no. Question. Did she ever treat you with disrespect? No. Mr. J, Judge, I'm going to object. This is character evidence. The court. Sustained. Mr. Beck, may I approach on this, Your Honor? The court. Yes. At the bench. Yes, sir. Mr. Beck, that was in direct response to the state having requested of Dr. Brennan as to whether or not there were signs of grandiosity that was presented by, by the hypothetical individual during the course of her life or any other circumstances. I'm refuting any sense the state may have left the jury with that Sarah Boone is grandiose or narcissistic. The court. Response? Mr. J, Judge, it's completely inappropriate to have been asked how she treated Miss Walker. What the doctor said clearly during testimony was that somebody can be very nice in one situation and be very different in a different situation. Yes, and I think that's exactly how Sarah Boone was. Sarah Boone would be very nice to people when she got what she wanted. The moment she didn't benefit from you, from the friendship, or the moment that she knew you were turning against her, she probably was really mean to you, Sarah Boone, okay, what the doctor said clearly during testimony was that somebody can be very nice in one situation, be very different in a different situation, so it doesn't provide any relevance as to the relationship between Sarah Boone and Mr. Torres, which is what the state's evidence is about. The court, what's your response to that? Mr. Beck, well, I think that's not what his testimony was. His testimony was as part of the corroborative process of evaluating or assessing an individual. You had to look at their interaction with other individuals. The court, unless the objection has morphed, I believe the state's objection is character. So that response goes to more relevancy as to why, but what's your response to character? Mr. Beck, well, one, character has been called into question by the state in the cross-examination of the state's witness. This has been called into question as a result of the cross-examination of Dr. Brennan. The character of the character of this witness or the character of this opportunity. Did I skip a line? The character of this witness or the character of the opportunity has been called into question, and this is an opportunity for the defense to refute the presumption by describing or at least giving the jury some sense of what kind of individual they are about to judge. The court, anything else? Mr. Beck, no, Your Honor. Mr. J, that's a misstatement of how the evidence works. They're called an expert witness. They're the ones that open the door to Ms. Boone's mental health. They're attributing her actions on February 23rd, 2020 to a stress disorder. And what experts have to say, have to consider in evaluating the credibility of the person in this case. The patient, client, relaying information to them are things that Dr. Brennan testified to and what Dr. Harper will testify to. Whether they're consuming alcohol, whether they have narcissistic personality disorder. So what's relevant is what Dr. Harper's perception is of the evidence that she reviewed. And that evidence is going to be largely based on 8 different meetings with Ms. Boone. So how Ms. Boone goes out in the world and interacts with Ms. Walker and anybody else isn't relevant because that's not something Dr. Harper considered. The court, anything else, sir? Mr. Beck, no, Your Honor, I think our argument has been made. The court, okay, I'm going to sustain the objection both as to character and to the extent that it's not being offered to show action and conformity therewith. I don't find that it's relevant. In open court, the objection is sustained. What else we got here? I think still an expert testifying in the stand. And did you consider Ms. Boone's upbringing informing any opinions? Answer, I did. Can you tell us a little bit about that? Answer, yes. So her history, I found it pertinent that she was raised with. Oh, I think this might be Dr. Harper now. Dr. Julie Harper. Objection, conduit 704. Approach at the bench. Response, Mr. Owens. I'm sorry. The court. She can't be a Mr. J. Conduit. The court. Gateway to inadmissible hearsay. Oh, I think, do you remember with the Amber Heard stuff, how she wanted to have her therapist notes admitted? And basically the therapist notes just relayed what Amber Heard said, what maybe happened to her by Johnny Depp. And I think that might be similar because those therapist notes were not admitted. And I remember after the trial, Elaine and Amber were like, well, there was so much evidence that wasn't admitted. You know, if the evidence was admitted and the jury saw it, then they would have believed Amber. And it's like, oh, it was not admitted because it was like all hearsay. It was all like the therapy note stuff. So I think it might be similar, like conduit. You're using another person to get your hearsay in. Okay. Response, I'm sorry. She can't be a conduit, gateway to an admissible hearsay in terms of the court. Anything that Ms. Boone has said to her, that question pertains to Mr. Owens. In terms of what her father passed away when she was in high school, the court, and if she's going to be eliciting statements are provided by the defendant to her, it's admissible hearsay. Mr. Owens, what about materials that she may have been provided in writing? What about that? Records and whatnot. The court, that's not pending before me right now. Right now, my understanding is that she's going to be testifying to specific statements that Ms. Boone has made, and 90.704 prohibits that. So the objection is sustained. I'll put that in my notes right now. 90.704. Florida statutes. Did I find it? Basis opinion testimony by experts. Florida. The facts or data upon which an expert bases an opinion or inference may be perceived by or made known to the expert at the time before the trial. If the facts or data or type reasonably relied upon experts in a subject to support the opinion expressed, the facts or data need not to be admissible in evidence. Facts or data that are otherwise inadmissible may not be disclosed to the jury by the proponent of the opinion or inference unless the court determines that their probative value in assisting the jury to evaluate the expert's opinion is substantially outweighs their prejudicial effect. All right. So the court says, nope, inadmissible. Move on. What's next? What did Ms. Boone, what has she been diagnosed with prior to getting involved? Mr. J, objection, 704. Oh, did I already read this? Nope. Oh, this is a different one. Okay. Approach, Mr. Owens. I didn't realize that was an objectable issue that she'd been previously diagnosed. I thought that was going to come out either. I thought it was going to come with Dr. Brandon, but I thought for sure it was going to come with Dr. Warner and some of the opinions that she expressed, because I know we took a deposition and she said, Dr. Warner said, yeah, I believe the previous diagnosis that she suffers from anxiety or some anxiety disorder. So I thought the experts, and of course they want to form their own opinions, but they're likely to rely on the history of other experts. The court, sure, Mr. Owens. So that was the reason for asking the question. I didn't know it was inappropriate to ask. The court, if you're asking her to rely or testify specifically to something that's inadmissible as to prior diagnosis, 704 prohibits that from happening. Mr. Owens, I understand. The court, and that's what I'm going to take the state's objection to be. Mr. J, yes, it's appropriate for exploration on cross-examination. Inadmissible evidence can certainly come in if it's relied upon by the expert during cross-examination. And it's certainly, I think an expert forensic psychologist or psychiatrist would testify. It hasn't happened here yet, but I understand that it could, so I'm not objecting. But this is the sort of thing that they're going to rely on. Like, I'm a psychologist. Yeah, it's within the course of my practice. Normally rely on other psychologists' diagnosis. The court, we just can't say what those diagnoses are. Mr. J, well, let's admit it to evidence already. And my understanding is that they're not doing it. Hey, Sheena, how are you doing today? How's it going? A handful of pages, but I still haven't been provided them. But it's going to come out in cross. It's just, I think it's under 90.704, which we just read, by the way. And according to Professor Erdhard, pages 954, 955 in the 2024 edition. And that's just for me to bring out. The court, he's correct. It's Mr. Owens. I've got the 23 edition, Judge. I don't have the 24. Time for you to get an update. The court says, but there's been no statutory change. So technically the edition that you have, Mr. Owens, should be the same. All right, judge says, but there has been no statutory change to the 90.704 statute in some time. Mr. J is correct. That's on cross-examination. He's allowed to explore the basis of the opinion and go into those out-of-court statements. You, as the proponent of the opinion, unless you have established the inverse 4-3 test, it's not admissible. Mr. Owens, I've been educated. All right. Good job, Mr. Owens. He's been edumacated. All right. Question. Is this Mr. Owens still, I think? Do some people with the syndrome dissociate? Objection. Relevance. Approach. At the bench. Yes, sir. Mr. J. We're at about 3 or 4 things where we're just going to ask about people in general. My understanding of discovery is that none of these apply to the defendant. And if it does, that should probably be the question. The court. Does disassociation apply to Miss Boone? Because if I understand correctly, that's what we're talking about. Mr. Owens. Dissociation is battered women. They develop a defense mechanism of being able to psychologically detach from their body during a traumatic experience. The court. I'm going to overrule the objection. All right. Let it in. The objection to relevance is overruled. Question. Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting. Mr. J. Judge, I'm going to object to relevance at this point. Approach. Yes, sir. Mr. J. Again, we're going into things that aren't even in evidence. There's no biting alleged. If he wants to ask hypotheticals about things that are in evidence, then that's acceptable. But again, we've been down this road for a few minutes now, and they're not being asked in the form of hypothetical, and there's no evidence in this case thus far that said these, like body dissociation or anything that she said. Response? Mr. Owens. Judge, she's testifying as an expert in the field of post-traumatic stress tied to the subset of battered spouse syndrome, what people will experience, and there's been testimony from Sarah Boone about what she all experienced. The court, I don't recall biting. Mr. Owens, I don't think there's any of that either, but I'm just asking questions about generally what do you look for and what do you find? The court, the question that was asked was specific things, kicking, fighting, biting. Mr. Owens, yeah, that's a general question. That's not specific to Sarah Boone. I didn't ask if Sarah Boone had been bit. I don't know she's been burned. I know she's been choked. I know she's been punched. I know she's been kicked. And I know she's been hit. Okay, anything further, Mr. J? Mr. J, I don't know. These things need to be asked in the form of a hypothetical, and they need to be based on facts and evidence. The court. Okay, I'm going to find that it's irrelevant. That it's relevant was your response to the improper form of question. Mr. Owens. I don't know what he means by that. Improper form. I can ask, are these acts that are committed by the abusive partner that are common to the court? If you want to ask, what are those acts? That may be acceptable. Mr. Owens. I don't think it's leading for me to ask. Is hitting common? The court. I would agree with that. Mr. Owens. I'll break it down. The court. I'm going to allow you to ask, re-ask and revisit that in another way. All right. So, I think the judge is so patient. He's even helping, attorneys sometimes with how they can ask their questions or if they're getting a little confused with the objections, stuff like that. Hello, Squirrels. How are you doing today? How are you, Sheena? How is everyone? All right. We are moving on through page 1,900 out of 2,500. moving on through. All right. Question. Who is this? I don't know who this is. You did interview Brian Boone, correct? Answer. I did not. You did not interview their child in common, correct? Answer. No. Oh, maybe the therapist, though. And you did review the phone text messages extracted from her device, correct? Answer. No, I did not. Question. Did you review any records from the jail? Answer. No. Question. And, gets cut off. Mr. Owens, Judge, may we approach at the bench? Mr. Owens. He's asked in a way to try to impeach her, and that's something that she should have looked at. She didn't do. We have an issue about that. We had an issue about that. Hold on, let me just read this whole fucking thing. He asked that in a way to try to impeach her, and that's something that she should have looked at that she didn't do. And we had an issue about that. So I don't think it's improper for him to ask that question. Response? I'm not following. You neither. I'm not following either. Okay, the court. Is your objection as to the lack of review of Orange County jail records or jail records generally, using that terminology, or is an objection as to what she did not review? Hi, Storm. How are you doing today? How's it going? Hello. Mr. Owens, I think he was implying first, what all did she review? And then he went into you didn't consider this. And when he goes into the jail records, he says records, but really it was jail medical records that we had that issue on. I don't remember if you remembered earlier. The court, when you're referring to Mr. Owens, excuse me? The court, this is the question directed to Mr. J. Mr. J, when you're referring to the jail records, are you referring to anything with regard to Ms. Boone's jail records? Mr. J, yes. The court, because I have concerns about that. I know she elicited that she's been incarcerated, but I'm trying to avoid any prejudice with regard to that. Mr. J, right. I'm just asking if she's reviewed any treatment records, but Ms. Boone is the one who had said that. The court, I know that, but it's specific as to Orange County Jail medical records. Mr. J, I can be specific. The court, okay, let's be specific with regard, sir, to your objection regarding Mr. J inquiring of these things. You can take up redirect if whether or not she needs to look at these things. Mr. Owens, didn't we have an issue where we agreed not to pursue the medical records? I thought we were attempting to get them, and the defense, I think, finally got them and was given them right before we were about to pick the grand. Let me just start over. Didn't we have an issue with where we agreed not to pursue the medical records? I thought we were attempting to get them, and the defense, I think, finally got them or was given them right before we were about to pick the jury. And Mr. J complained that it was so late in the game that he was going to have to take time to review all the records over the weekend during his private, personal time. And then ask, I think maybe to reduce them down. I can't remember. The court, there were 382 pages. This looks like it's like item 6 of the defendant's Fifth Amendment reciprocal discovery exhibit list. Certified medical records from the Orange County Jail, not yet received by the defense. The objection was filed. My notes reflect that 382 pages were provided on October 17th to the state, and I think we had cuts off. Mr. J, that would have been after jury selection. The court, I think it was during. Mr. Owen, oh, it was during? The court, it was during. I don't know that we had finalized because I think it was delivered to them that morning on USB drive, potentially on the 17th, because that was last Thursday. Mr. Owens, it was starting to all blend together. The court. My only notes are that there's something about an intake screen on page 135 through 138. Mr. J, so we had discussed what particular pages they might be seeking to introduce. The court, they were looking to introduce. Mr. J, what I'm asking now is, did she rely upon records that are routinely relied upon by experts in her field, which would include diagnosis? The court, I totally get that. Mr. Owens, and that's the whole reason that I wanted the records, is that I wanted her to review them so this very question would not be asked. You didn't review the records. You should have done that. That's why we got the information as soon as we could. We got it from the jail. It was during jury selection, which was 4 days. I think it was on third day. We hadn't sworn the jury yet. We got them immediately. We gave it to them, and he complained because there's so many pages. He wanted them pared down. Eventually, we had agreed to stipulate that we wouldn't, gets cut off, the court, use them, but that was for the purpose of admitting them into evidence. Mr. Owens, I know, but now he's trying to use them against me, and I was doing him a favor. Mr. J, I had reviewed all the records. What we're discussing was what was going to be admitted into evidence. The court, correct. I agree with Mr. J. Mr. Owens, I'm just trying to be a colleague, and now he's using it against me. The court, But the discovery, the exhibit list was solely as to what was going to be sought to be entered into evidence at that time, whether it was you, the whole kitty of everything that may be admitted. I agree with you that Mr. J was, had an issue with 382 pages. Let's take the time, frame out of it, that there were 382 pages, and the issue was calling it down. The only note I have is an intake screen from pages 135 through 138. I don't have any other, but I recall the defense at the time, after discussing, had abandoned attempting to move those into evidence. Whether or not she reviewed them or not, I think is fair game for cross-examination. Mr. Owens, wasn't there some talk about that, about whether she could review those? Because I was going to send them to her. You remember, Judge, I was going to send them to her and you made a ruling. So I said, I'm going to stop sending them to her. And I think you showed an email or showed you a text message that I had sent it to her. It's on my phone where I said, do not review, in bold capital letters, do not review the medical records. The court, if you want to go back and look at your phone and see if you can do that, I just can't remember. Do not or consider the jail medical records of Sarah Boone. That was October 17th at 1:06 p.m. Kuya says, feels great. I'm lying in bed, free to go wherever I like, eat what food I buy. But Sarah Boone, recording every day, hating life in jail, reflecting how hard she messed up. Imagine going through what a life sentence. Yes. And then probably sleeping on beds that are uncomfortable. Like Donna, did you follow the Donna Adelson case? Donna Adelson, older woman complaining about jail conditions. I can't imagine jail being comfortable when you're in your 70s, 80s, even when you're younger like me. But yeah, when you're older, whew, that's a tough one. And I think Donna said she suffers from sciatica or something too. You need some special mattress, some exercise. Oof, oof, oof. Uncomfortable. All right. The court says, here's what I'm going to do. I'm going to, I'll give an opportunity to go back and confirm what it is that she has relied on, so you're not ending it at a weird point. I'll leave that to your discretion, but I'll sustain the objection with regards to Orange County jail records specifically. Objection. Who is objection? Okay, I think Mr. Owens is objecting. All right, Mr. Owens is funny. Question. In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer. I based my opinion on the information that I had. Certainly, if there's any more information, my opinion would be subject to change. Question. What was your opinion? Answer. My opinion is that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail. Question. And specifically talking about Mr. Owens. Judge, can we approach the bench? I think this might be Dr. Warner, who's testifying right now, who is an expert for the state. Remember, we had issues with Dr. Warner's testimony because if she had a change of opinion about something, or if she had more opinions about a certain topic, she was supposed to alert Mr. Owens, and she didn't do that. So that was a huge issue. And then they had to do, Mr. Owens had to do a impromptu deposition outside the jury's presence. All right. The court. What's the legal objection, sir? Mr. Owens. I don't know if it's a legal objection, but Dr. Warner evaluated Sarah Boone at the Orange County Jail on October 2nd. 2 days later, on October 4th, I took her deposition on several of the issues, and she said, I have not formed an opinion as to whether or not she suffers from this or that. A couple of them, she said she was convinced that she suffered from alcohol abuse syndrome, but on issues like post-traumatic stress, issues like battered spouse syndrome, I think it's a couple more issues, she said. I would need more time to reflect. Since I just saw her 2 days ago, I would need more time to review my notes. She said it would probably be a couple more hours that I would need to spend on it. And then I said, well, can we agree between the lawyers that if she forms any opinions that the defense will be notified? I was not notified. The court. Okay, Mr. Owens. That she formed this opinion. The court. Mr. J. Mr. J. My expected answer from her is that based on what Sarah Boone said about the events, that battered spouse syndrome is inapplicable because Mr. Torres and her were laughing, and that it was her who decided to get angry and would not let him out of the suitcase. That's all I'm trying to establish with her. Mr. Owens, I understand, but we had an agreement that if she changed her opinions that you would let me know, and we could agree that I could retake a deposition. The court, give me a moment. Mr. Owens, it was an agreement, Judge. I'll show. The court, that's what I'm pulling up right now. Mr. Owens, it's mentioned on several pages. It's more than the court. Do you have specific pages in the transcript that address this agreement? Mr. Owens, it starts at line 38. Court page 38. Mr. Owens, well, I start to ask her on line 17 that she responds on line 21, but it goes on for several pages after that. The court, this pertains to adjustment disorder, if I'm reviewing it correctly. Mr. Owens, well, it keeps going on, Judge. Like I said, several pages. The court, I know, I'm on 41 right now, specifically page 41, line 15. This is from Dr. Warner. So she's saying, I'm assuming that's Boone. She's has generalized anxiety or disorder. And I'm saying I want to review it more to see if I think it's more of an adjustment disorder to being in the correctional setting right now and the stressors that she's under right now as opposed to general anxiety disorder. Mr. J on line 22 then states, okay, so on this topic, if something new comes up, then we can address it. But if other topics dispose are on, then I suggest we move on. Moving to 42, line 1, Mr. Owens, I agree. Dr. Warner, just let the state attorney know. I know that you may, we are short on time if you do review your notes over the weekend and whatnot and formulate any other opinions. Just let the state attorney know and we'll address it. Witness, absolutely. Here's the thing. When the witness testified, it seemed like she was just really fucking busy, and that her coming out here to testify and her doing the Sarah Boone case, it seemed like she just absolutely had almost no time in her hands and she just really rushed it. This is the state's witness, by the way. Honestly, I think she just forgot, and I think she just rushed everything. And then that's why she didn't alert Mr. Owens about her new testimony or her new opinions about Sarah Boone. I think she was just very busy and overworked. Because I think she was talking about how her real job, she works there I don't know, maybe even 7 days or something like that. But I think she was just really busy. And I did feel bad for Mr. Owens when this happened. Mr. J, I think it's page 46. I think the problem is that she didn't answer the question that I'm trying to ask her on page 46. Court, line 1, Mr. Owens, just need to read 46. The court, okay, let me read 46. Give me a second. I mean, unless I'm missing something, it's lines 13 through 15. She identifies that as, unless I misunderstood the question or answer, it's in the depo. Mr. Owens, I would have to look through my notes to see if she fully met the criteria. The court, but the answer is no. Question line 13, page 46. But you don't believe that she suffers from post-traumatic stress disorder in your opinion? No. Mr. Owens, look at line 19. The court, I'd have to go through my notes. I back through my notes to see if she fully met the criteria. I'm sorry, hit the wrong button. Line 17. Can you explain why you don't think she suffers from? No, I don't think I didn't say that one way or another. I would have to look back through my notes for that. Is that something you may in the future give an opinion on about after some time reflecting with your notes? I may. Okay. Mr. Owens, 25. The court, okay. That's something you will let me know that changes. Yes, okay. Mr. Owens, and then the court, just for the record, that's 46, lines 25 through 47, lines 1 through 2, the deposition of Dr. Warner. Mr. Owens, should it go all the way through several? The court, okay, well, the issue right now is the PTSD, is the opinion on PTSD. So what I don't hear is a legal objection. Mr. Owens, we had agreed. I don't know if I can find the right page, but we had agreed to retake a short deposition. Maybe if you give me some time, I could find where Mr. J said, I will agree to a short deposition if her opinion changes between now and the time of the trial. And I relied on that because she would not be pinned down. If you'll give me a few minutes, I can find it. Do you want to let the jury out? The court, I think we're going to have to at this point of time. Mr. J, do you have anything to add just for my own edification at this time? Mr. J, again, Judge, what I'm trying to establish with this witness, regardless of whether Miss Boone had PTSD, ABCD, or XYZ, fucking Mr. J, or anything else, that it doesn't matter based on what Miss Boone specifically told her about the incident. That's all I'm trying to get out. The answers went divergent from the question. I don't think I'm violating an agreement because her opinion had not changed. I was only able to speak to her for 2 minutes yesterday and just asked her about the specifics of does this apply given what she said about the event. And that's not something that's new from the deposition. The court, all right, let's remove the jury for a moment. Thank you. So again, this is where we had some major sidebars, some major breaks, and the jury was excused or brought back in, and then they were excused again because we had issues with Dr. Warner, her testimony, and how she formulated a new opinion and did not tell Mr. Owens that she was supposed to reach out to the state and then let them know, and then also reach out to the defense, and that didn't happen. Mr. J, state would move to strike the last response as non-responsive. Approach the court. Any response? Mr. Owens, I disagree. I think that's the one where we talked about I'm going to be able to use to impeach her with her statements that she made in the deposition versus the statements she made today. If I'm referring to the correct response, which response is it? Mr. J, the last question I asked in front of the jury, she gave a non-responsive question. Oh, I think that's when they brought the jury back in and then they continued the questioning. The court, what's your opinion? My opinion was that she did not give enough information to diagnose her with PTSD at the time of evaluating her at the jail. Mr. J, well, the question before that is what's relevant. The court, what else did you rely on? Mr. J, no. I basically asked the same thing that my proffered questioning was asking. Then she gave this non-responsive answer that caused all of this. The court, I'm going to overrule your request. The question was, what was your opinion? And the answer to that last question was, what was your opinion? All right. I think at this point, he was basically objecting to his own witness, or strike. The last response was not responsive for his own witness. I'm pretty sure they are going to excuse the jury again soon. Yeah, I think right around here. All right, question by Mr. J. And what particular part of her statements about that incident is that? Answer. The whole part where she's describing the part about playing hiding and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up, they were still laughing, having a good time. All that is inconsistent. All of that isn't consistent with her having a feeling that she's at imminent risk or imminent fear, that there was an imminent risk of harm. Mr. Owens. Judge, I'm going to object. Can we approach the bench? At the bench, Mr. Court, or Mr. Court, the court. Legal grounds of the objection. Mr. Owens. Judge, I don't object to her expressing. The court. What are the legal grounds of your objection? You just said I object. What are the legal grounds? Mr. Owens. Is it improper response to a question in the ultimate issue of the fact of being asked by the prosecutor? It's an improper answer to the ultimate issue of the fact is for the jury, not for her. The court. Response. Mr. J. This is no different than the expert saying insanity applies or doesn't apply. It's their expert opinion on what portion of the law and it's permissible, on that portion of the law and it's permissible. Mr. Owens, I do not believe that the court, just because, even assuming that the answer embraces an ultimate issue, that doesn't mean it's objectable. It doesn't mean she's committed homicide. I'm not saying she committed homicide. I'm not saying she's negligent. It's not saying that she's punitive. It didn't go to any one of those specific elements. Mr. Owens, she's not expressing a medical opinion. She's not expressing a scientific opinion. She's expressing an opinion as to whether or not her behavior, her conduct, her statements constitute an imminent threat. That is a province of the jury. The court. She didn't say that. Mr. Owens. Yes, she did. The court, or Mr. J. This is exact same thing as a doctor saying somebody didn't appreciate the legal consequences or did. This is an interaction of the intersection of the law and psychiatry when this testimony comes in and it's not objectionable. Mr. Owens. Think about what she said. She's also been telling the jury that there was not an imminent threat. That's the question for. Gets cut off. The court essentially telling the jury and telling the jury are two different things. What specifically did she say, Mr. J? Mr. Owens. She mentioned, we can't have the court reporter read it back, but it's a critical issue, Judge, about the ultimate issue of the fact, but whether this psychiatrist, based on history, my client gave to her 4.5 years after this event, whether or not I believe as an expert, no, the defense doesn't apply because she was not perceiving an imminent threat. The court, but the question didn't ask about a defense, unless I missed something. Mr. J, I agree. That's just absolutely no different than if an expert. Hold on, let's go back to what she said. She said this. She said that they were playing hide and go seek. They were having a good time. They were laughing. He got in the suitcase. She found him. They were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of this isn't consistent with her having a feeling that she's at imminent risk or imminent fear, that there was an imminent risk of harm, and then she gets cut off. Okay. Hey, Tanika, how are you doing today? Hello, these are juicy. Hello. How are you? Thanks for popping on in. I hear the family court stuff is really interesting. I've not read of any of that stuff yet, though. All right, to the extent Madam Court Reporter reads it again. Oh, I guess, did she read it again? Oops, I should just let her read it again. All right, let's go back. Mr. Owens. She mentioned, I do not, and we can have the court reporter read it back, but it's a critical issue, Judge, about the ultimate issue, the fact of whether this psychiatrist, based on a history my client gave to her 4.5 years ago after this event, whether or not I believe in it as expert, no, that defense doesn't apply because she was not perceiving an imminent threat. The court, but the question didn't ask about a defense unless I missed something. Mr. J, I agree. That's just an absolutely no different than if an expert. Mr. Owens, I think we need to reread the question and reread her answer. This is a critical issue about guilt or innocence that she is expressing. The court, are you able to reread it for me? Mr. Owens, Judge, I'd ask that it be done outside the presence of the jury. The court, to the extent possible, if I have to, Madam Court Reporter, come up here and do that, I will do that. All right, disconnect, members of the jury. Did they ever... I think this was done in open court, right? Open court. Yeah, open court. Okay, they tell the jury to leave. See how long? Oh my god, this is pretty long. Mr. Owens. Yeah, I remember Mr. Owens was kind of pissed about this because of what Dr. Werner was saying. He's saying that the jury is the one that should be determining whether or not self-defense was justifiable, and whether or not Sarah Boone perceived that there was an imminent threat or not. And the court did overrule the objection. Actually, let's just read it. Could we just read it? The court, thank you both for your arguments. The court is going to overrule your objection and find that it's not the ultimate issue of the fact as addressed by 90.703. The court specifically relies on Dinkins v. State 976 as pinpoint 661. In that case, a psychologist testifies in the incident case in Dinkins. The psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocent. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective and, quote, incapable of consent to intercourse. Although opinions did not go to the ultimate issues in the case, Florida law, expressly provides that an expert opinion may render such opinion. See section 90.703 Florida statute. Mr. Owens is like, see what now? Let me look this shit up. Which provides testimony in the form of the opinion or inference or otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of facts. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled. All right. Mr. Owens is not happy. What's going on here? Madam Court Reporter, I'm just going to have you read the question and answer the jury. Then I have no further questions of the witness. The court, okay, thank you. Mr. Owens, I'm sorry. The court, he's going to have Madam Court Reporter read the question and the answer, and then he's going to have no other questions for this witness. Mr. Owens, I object. Basis, it was asked and answered. The court overruled. There's a pending objection. I'm going to allow the state to re-ask it so it's a clear base on that objection. Judge, it's 11:30. I'm going to be at least an hour for my cross-examination. Jury enters back in. I think they have the Madam Court Reporter ask the question and then reads it back. And then Mr. J says, no further questions. All right, cross-examination. Now, cross-examination was very spicy, I would say, because Dr. Warner... she had I give no fucks about anything when she was doing the cross-examination. When she was being cross-examined by Mr. Owens. Poor Mr. Owens, man. Okay, Mr. Owens. Is this with Dr. Warner still? Possibly, maybe. My Mr. Owens. You said you consider some text messages from Sarah Boone's phone. I reviewed them, correct. Would it be correct to say that those text messages that are not necessarily overly relevant? Mr. J, objection. May we approach? Yes. Yes, sir, Mr. J. This is outside the scope of what she reviewed for opinion that were expressed today. The opinion she expressed today was based on the evaluation of Ms. Boone. Court response. Mr. Owens, Judge, she considered everything that was given to her. She reviewed everything that was given to her before she went to the jail and had interviewed Sarah Boone, so that she had that in her mind when she interviewed her, Sarah Boone. Is he okay? And her opinions are tied to the paperwork that was given to her. That's standard operating procedure of any expert in this field who relies on collateral sources, as well as the assessment made of the patient. The court, any response? Mr. J, may I voir dire the witness then and ask her, did this inform your opinion as what you just expressed your inapplicability? Why is the font dying? What you just expressed about inapplicability of BSS? Is that BSS? And PTSD to the facts of this case. I don't know. Something happened with the paper. The court, but it was provided to her, correct? Mr. J, right, but she did not express that she relied on it. The court, yeah, I'll allow you to voir dire the witness. Go ahead. All right. So I think the judge is still not in here. Oh, so not the judge, the jury. Yeah, I think they're still doing the voir dire of Dr. Warner and the jury is not in. All right, let's see. Question, and you're going to express some opinions here today, are you not? Answer, correct. Question, you're going to express some opinions about narcissism? Mr. J, objection, may we approach? The court, yes. We're at the bench right now. Oh, that was Mr. Owens asking the questions. Mr. J, this is outside the scope of direct. I didn't ask her about narcissism or any of the things. If they want to recall my witness, they can, but this is way outside the scope of the cross. The court, response, Mr. Owens. Judge, this is an expert witness. We've given wide latitude to cross-examination. I can't believe you're trying to limit the court, but she didn't offer any opinions on narcissism. So what facts or consequences make it more or less probable? Even if it may be in the deposition, what does it matter for the purposes of today based on what she rendered opinions on? Mr. Owens, I'm allowed to question her on any opinions that she may have about my client. Just because they specifically only want to ask her about one opinion that she has about the issue does not limit me from asking an expert opinion in psychiatry about any of the conditions that she may or may not suffer from as it relates to the ultimate issue that she's expressing, and asking the jury to decide on the issue of self-defense, battered spouse syndrome, whether she acted appropriately under the circumstances. The court. Anything further? Mr. J. Judge, the reason that the state went into narcissistic personality traits that Dr. Harper expresses that she has, and the reason we had Dr. Brennan explain all these things was because it was specifically relates to the credibility of the patient or the client informing the doctor, and it goes to the weight and credibility of the opinion that they may render. So what we got into is the alcoholism. That's what we got into the alcoholism with. That's what we got into the narcissism with. And all those things were asked and answered by their experts as to directly relate to the credibility of the historian giving that information. So if he wants to impeach his client's statements about having her express that she opines that she had narcissistic personality tendencies, it's on them. But the court, I'm not addressing that. Mr. J, it's not the basis of her opinion. Mr. Owens. Dr. Brennan testified, Dr. Harper testified that it's standard operating procedure to rely on all of those. The court. But that's not the issue. The issue right now is whether it's outside the scope. That opinion was not offered. I'm going to overrule the objection, but I find that it has really limited relevance based on what her opinions were. But I'm going to allow you to proceed on it. Mr. Owens. Well, Judge, if I'm not allowed to explore the court, that's not what I said. Her opinions, that's not what I said. What I said was, I'm going to allow you to do it, but she didn't offer those opinions. Mr. Owens. I understand that, and I'm allowed to cross-examine her that she didn't find certain diagnosis. The court. The only issue for me right now is an opinion on narcissism. The state's objection is that it's not being offered. That's not relevant. I'm going to overrule their objection, but just be mindful that they're not offering any of these opinions. Mr. Owens. Well, it goes to the other objection about whether I can go into what other evidence she relied upon in expressing her opinion as it relates to Sarah Boone. She relied upon collateral sources, including, gets cut off, the court. That's not what's in front of me right now. The issue is not in front of me. There's been no objection to that at this point in time. The only objection was to the text messages, and it was not a basis. Mr. Owens, can we go ahead and talk about it? Sure, go ahead. Mr. Owens, well, I think this all started when I was talking about, ask the expert, Dr. Werner, about Sarah being cell phone records, and I believe the state attorney provided her. I'm not sure if it was. I'm pretty sure it was the text messages from the cell phone. And I believe it was testimony from Dr. Werner is going to say, and the reason this comes up is I know they're going to introduce a bunch of text messages. The court, what are you trying to get at? Mr. Owens, Judge, I guess. The court. If you're getting to the basis of her opinion and what was relied upon, you're absolutely allowed to do that. But you have to understand, based on what opinions were elicited during direct and what the courts heard, none of that mattered for the purpose of the opinion she testified for today. If you want to do that, I'm not going to foreclose you from doing that. It's your decision. Mr. Owens. If they're going to be objecting to me asking all the information, all the evidence, I'm going to get into the medical records. The court. I'm going to. Mr. Owens. I'm going to get into the Advent records. The court, if that was the basis of your opinion, you're allowed to explore it. That's all I'm saying. Mr. Owens, are you going to be objecting to, Mr. J, the testimony that she gave was outside materials that were absolutely irrelevant to the opinions she gave? Hey, Joe, how are you doing today? How's it going? The court, I understand that. Mr. J, and the court, I understand that. If he wants to explore it, he can explore it. It may not be beneficial. I don't know. Mr. Owens, I need a ruling, Judge, because if you're going to rule that I can explore it, the court, I've already ruled it, sir. I said you can explore it. I said you can. Mr. Owens, okay, but the court. The problem is I don't know what the utility of that is going to be because of the limited scope of the opinions. She didn't rely on anything of that stuff in informing the opinions that she's done that today. If you want to do that, you can do that. I'm not going to say no. Mr. Owens, okay, his suggestion was, and my thing is, I'm going to get into medical records of Sarah Boone, and I'm going to get into the specific notes about those medical records relating into her Baker Acts. The court, okay, Mr. Owens. If that's going to be objected to, it's because it's not relied upon, then I'm going to need to call Dr. Werner as my own witness, as an advert witness. The court, okay, wait a second here. Okay, did she rely on medical records? Mr. J. She was provided them, but her direct testimony that we all just heard together was it did not inform her opinion that BSS and PTSD, BSS battered spouse syndrome, okay, and PTSD do not apply to the facts of this case. Take a sip break. Oh, my mouth is getting dry. The court, if you're able to tie that, she relied on them somehow. We can address that. It doesn't address any issue of hearsay or 704 issue. Mr. J, well, experts, just like I did. The court, on cross-examination, you're allowed to go into it. Mr. J, if an expert relies upon what she testified today, she did not rely upon it. So each time he brings up a new piece of evidence, I'm going to voir dire her and ask her if that informed her of one opinion she gave. Mr. Owens, Judge Kradick. Yes, sir. Hi, Diane. How are you doing today? Mr. Owens, that's what I'm getting at. Let's not bicker and fight about this. If he's taking a deposition, or if he's taking a position, sorry, my mouse hovering over it. If he's taking a position that he's going to object to everything, but he's not going to if I call her as my own witness and I can treat her as an adverse, the court, no, I don't think it's the same. Mr. Owens, witness, let's do it. The court, it's the same problem. Mr. J, you can't, the court. But he's correct on that. 90.704 prohibits that. You're allowed to do it on cross, but the problem is it's not the basis of her opinion of what was offered today. So 702 tells us what we need to do, how it's relevant for the purposes of her opinion that was provided today. Yeah, I looked at those medical records, but they have nothing to do with opinions I relied on. I opined on today. Mr. Owens, that's not the same issue. The issue is cross-examination and wide latitudes allowed, especially for an expert witness. The court, you're not answering my question. The opinion that was offered was, this is my opinion. BSS and PDSC are not applicable based on what was reported to me. How do the medical records have anything to do with that as a sufficient fact and the data point that she relied upon to render that opinion? That's the first step. Mr. Owens, it's her opinion. I can expose her opinion as not reliable. I can expose that she admits that she suffers from battered spouse syndrome. I can expose her opinion that she suffers from alcohol use syndrome. I can expose her opinion that she suffers from anxiety disorder or adjustment disorder. I can expose her opinion that she meets some criteria for narcissism and she relied on those records in formulating that opinion, as every expert does in the field. I'm granted wide latitude to go into all that to express, to attempt to impeach, to show that she's biased, to show that she's a state's witness and that her only job is try to help the state win their case. Boom. The court, I understand. I'll allow you to proceed, but you're going to take answers as they come because if she keeps saying it had nothing to do with my opinion today, that's what you're going to be stuck with. I don't know what she's going to say, but the state's opinion was very truncated as to what they're offering for her. Hey, Sean, how are you doing today? I'm doing good. Hello. Oh, you're making some chicken fajitas? Oh, yummy. That sounds good. What kind of, what are you adding to the fajitas? Mr. Owens, and for my position with the state attorney is if you're going to be objecting every time and you're suggesting that I just call her as my own witness, I'm willing to do that just to save some time because I don't want to get into this and spend 10 minutes up here every few seconds. If it would be better, I'll just call her as my own witness. The court, anything else, Mr. J? Mr. J, just so that we understand the law, you can't get into admissible evidence on direct. The court, I know that. Mr. J, and there's no basis for a sir rebuttal case. So basically, they're saying if you call her as your own witness, it's the same thing. There's not going to be a different effect. The court, I'm not addressing sir rebuttal at this point in time, but he's correct. 90.704 is going to prohibit her on direct examination from testifying directly to inadmissible evidence. Cross is a different kitty. The rule specifically addresses that. I'm going to allow you to do it, and you can object, Mr. J. And Mr. J, I'll just ask for a voir dire. The court will address it as we go. You may proceed. Objection is overruled. Actually, now I kind of want to know what happens here. Let's read this. Mr. Owens, ma'am, is it fair to say in your evaluation of Sarah Boone on October 2nd, 2024, that you felt the text message you received from the state attorney, objection, beyond the scope, overruled by Mr. Owens, are not relevant to the evaluation of Sarah Boone? Withdrawn. The witness, I wasn't sure at the time I wasn't sure whose phone number it was, in all honesty. We discussed in the deposition. I wasn't sure I had proof of who actually sent the text, who actually had possession of the phone and put the text. Oh, that's right, because Sarah and George were essentially sharing phones, and you can't really tell who was texting. I feel like you could. I feel like you could tell, which one was Sarah Boone and which one was George. But I think the defense is trying to say that, you don't know who was doing these text messages. You don't know who was writing these notes because Sarah Boone and George were sort of sharing the phone. Mr. Owens, well, I was there for deposition. Was I not? I appeared on Zoom. Did I not? No, sir. You were present in person. Do we get anywhere? Phone records. We discussed what was on the phone records from Sarah Boone's phone. Answer, yes. Question. Okay. And at the time, you said they are not necessarily overly relevant to your evaluation. Did you say that? Answer. I don't recall specifically. I'm happy to look at it if you turn me to the page. Question. May I approach the witness? You may. I have it. May I have voir dire? Just a moment. Mr. Owens, you got it. I do. Question. Page 14, my question is at line 3. Your answer begins at line 5. Answer, correct. Question, and do you agree with that? Mr. J, Judge, permission to voir dire based on the court. Let him finish. Mr. Owens, I'm going to ask another question about the text messages, Judge. The court, you just said line 5. Approach at the bench. The court, I asked her to refer to page 14, line 5, and I have a depo in front of me. It says, I was aware of them, but not necessarily overly relevant. But they're not necessarily overly relevant. Mr. Owens, that's correct. The court, so what are we doing? If you're going to ask her to rely on that and ask her about the text messages, you need to give her the opportunity to say, this is what she said. Mr. Owens, all right. Question, Dr. Warner, did that refresh your recollection about the discussion about the text message in your evaluation? Answer, yes. Question, and would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone? Answer, correct. Question, and you agree that after reviewing all those text messages, there's nothing that struck out to you that caused you to pause and feel like they may have some impact on your evaluation of Sarah Boone? Mr. J, permission to voir dire. Mr. Owens, can't she answer the question? The court, have her answer the question first. The witness, I'm not sure what you're referring to in the deposition. Okay, so we're talking about, I don't know, I just kind of want to know what happens here. I don't remember this. Text messages. Page 14, the question's at line 21. Your answer is at line 25. Correct. And I said no. As I said, it made me aware that they had a volatile relationship. Question. But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations? Answer. Correct. And you agree your answer is no? Answer. As I said, it made me aware. That's not my complete answer. Question. Okay. First, you said no. Answer. As I said, it made me aware that they had. Question. Ma'am. Answer. It's not my complete answer. Question. I know, Dr. Warner, but you didn't say no to me. That was your first sentence was no? Answer. It's not my complete answer. Question. I understand. I want to let you answer that, but when I asked you if there's anything in the text messages that caused you to pause and it would be in some way after the impact of that would affect the impact of your evaluation, your answer to me was no? Answer. It's not my complete answer. Question. I understand, but your answer to me is no? Answer. Yes, but that's not my complete answer. Question. Now at the time, Dr. Warner, at the same time, you expressed that they had a volatile relationship. Answer. That's not the totality of my answer either. Question. Okay, I'm going to get into it. Okay. But part of your answer was that they had a volatile relationship. Correct. And this is in relation to the question about the text messages. You agree? Yes. After you said no, you said they had a volatile relationship, that she texted calling him a fucking idiot for overdrafting her account. Correct. And in those text messages, there was some reference to domestic violence between the two. Correct. And that demonstrated to you that they had a violent relationship. Correct. And do you not agree that the evidence of a violent, volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome? Judge, I'm not going to object. We need to approach. Okay. Yes, sir. Mr. J, I didn't offer an opinion that she suffered from battered spouse syndrome. The court, what's your legal objection? Mr. J, it's outside the scope. The court response, Mr. J, and it's misstating. Mr. Owens, Judge, this is cross-examination of an expert witness. I'm allowed to explore impeachment, bias, prior inconsistent statements, whatever the standard cross-examination. I'm allowed a lot of latitude. Cross-examination is fundamental to defendant's right to a fair trial, especially the court. But what does that have to do anything to do with anything if she's not? Does she render an opinion as to this issue? Mr. J, yes, just earlier outside the presence of the jury, she said my client did suffer from battered spouse syndrome. Mr. J, the state didn't offer that. The court, your objection is outside the scope? Yes. My objection is overruled. Mr. J, and relevance, misstatement. The court, how is it a misstatement of facts? Mr. J, because she had not testified to that in front of the jury. The court, that's fair. Mr. J, I'll ask her. Mr. J, or Mr. Owens, I'll ask her. Mr. J, and we're going to object. He can explore and cross-examine her opinion that she rendered and point out all the things that she should have looked at and didn't, and that's fine. But now what he wants to do is have an imaginary direct examination that I didn't give her. He imagined that I was going to go into all this stuff, and I didn't. This is all going to be outside the scope because she didn't rely on anything for the opinion she expressed except for Ms. Boone's evaluation from October 2nd. The court. Anything else? The judge. Mr. Owens. Judge, I got Earnhardt down in the car. I mean, I don't know if you need to take a break for me to get that, but I don't have that rule. But she expressed several opinions relating to Ms. Boone in her deposition that gets cut off. The court. But just because they're in the deposition doesn't mean it's necessary for trial. We all know this. Mr. Owens, They directly affect my impeachment of her on the opinion that she expressed on direct. I'm going to make those arguments. My cross-examinations are going to be tied to my closing argument in relation to limiting her opinion when she had other opinions that were not disclosed by the state, the court. I'm not going to get into that disclosure or non-disclosure. We've already addressed that. Mr. Owens, no, I'm talking about that he didn't ask her on direct. He limited his direct. The court, that's his choice. Mr. Owens, exactly. I'm allowed to explore all the others and then argue that he didn't explore those issues. He wanted to limit. The court, I'm not going to allow that. That is improper closing argument. That is complete improper closing argument. That is demeaning the credibility of an adversary. You are attacking a person. That's an ad hominem attack. You're not allowed to do that in closing. He didn't do this. It was his choice. He didn't do that. You can't do that. Now, if you want to talk about the opinions that she's offered, that's a different kitty. But I'm not going to allow you to attack Mr. J or you, Mr. Owens, to attack each other in closing arguments. Spoiler alert, I think Mr. Owens does attack the state, and then they have a sidebar about that. Grilling some peppers and some onions. Ooh, yummy. Any jalapenos? I have another batch of the green chili chicken enchiladas that I have to cook. I need to get more tortilla, though. All right. I'm not going to allow you to do that, Mr. J or you, Mr. Owens, who attack each other in closing argument. We are not going to do that. I understand stress is high. I understand tensions are high. We need to bring down the boiling point. But I am not going to allow you to attack each other one way or the other in closing. Mr. Owens, can we have a break? I'd like to go get the Earnhardt. The court, I'm going to allow you to do that. Mr. Owens, I understand, but I'm a little hot right now. I think a break would do us all some good. I feel like if I had a chance to get Earnhardt and review it, I could point to the issue. Obviously, this is a critical issue in this case. The court, I'm not disagreeing with you. All right, 12 o'clock. The court, I'm not disagreeing with you. Mr. Owens, I'm about to blow my top. Mr. Owens needs a break. Good. He needs a break. Let him chill the fuck out. The court, okay. I don't want that to happen. I don't want anyone to blow their tops. Mr. J, anything else? Mr. J, no, sir, just that cross-examination. We understand what cross-examination of an expert entails. If an expert comes in and gives an opinion about A, certainly attack that. But just because I chose not to give her opinions B, C, and D doesn't mean he gets to bring them in and attack them. The court, here's what we're going to do. We're going to go ahead, take a break, and then I'm going to ask the jury to be back here at 1:30 p.m., and then we'll pick up from there. Is there any other argument you're going to make other than outside the scope of relevance with regard to Mr. Owens' opportunity to explore these other opinions? Mr. J, depends on the questions asked. That's fair. Mr. J, but again, if he's going to say, well, text messages or Aspire records or whatever, when the opinion she offered today was not based on it, I'm going to object to the relevance of it. Okay, I got it. Mr. Owens. And Judge, I want to review Earnhardt. I'll further response if something changes. Understood. Okay, thank you very much. All right, so we are going to have a little lunch break before Mr. Owens blows a lid. I actually have never read this part before. I think I accidentally, I must have missed it. All right, well, I'm going to continue to, whoops. Let me highlight this. Highlight, please. Highlight everything. All right, that way we have it. All right, next one. Bench time. I don't think this is anything crazy. All right, what about this? I think this is it still Mr. Owens? I think so. Mr. Owens doing his cross of Dr. Warner, possibly. Question. When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder? Answer. It was probably within the next week when I was reviewing all of this, going through all the documents and her interview more thoroughly. Question. Dr. Warner, did you agree that you did not notify me? The judge. Mr. J. Judge, may we approach? Yes. Yes, sir. Mr. J. I didn't ask her for any of these opinions, so I don't see the relevance. The court. What are we doing, Mr. Owens? Mr. J. And it's improper. The questions. Mr. Owens. Oh, sorry. Mr. J says it's improper. The questions. Mr. Owens. She's making an opinion here today in court. The court. Then there's another way to ask it. Mr. Owens. When she told me, the court, there's another way to ask it. Hey, this is the first time you've rendered this opinion. You did not render this opinion in your deposition. That's the other way of asking, other than saying, hey, we agreed and you lied, and anything along those lines. Mr. Owens is charged up. Okay, he's fired up right now. That's why, Judge. Mr. Owens, She said some things in depositions that she would notify me or notify the state attorney if she had changed in any of those opinions. She failed to do that, Judge. The court, there was no change. There was no change. We've been over this. Mr. Owens, Judge, at that time, let me get through the transcript. Oh, let me get the transcript. The court, Mr. Owens, I don't need to reread the deposition transcript. You provided to me. I'm familiar with the portions that you're relying on. Mr. J, Judge, it's improper for him to ask about opinions that I did not then again cross-examine her on. Had I wanted to get her opinions on these things, I would have sent her all these records that we have. I didn't want to delay the trial when she gave me her opinion that battered spouse syndrome didn't matter in this case, so I foregoed giving her any additional records that I could get valid opinions, and now she's being allowed to ask about these opinions and then cross-examine them on her. It's improper. The court. The question before the court is improper. That's impending right now. I find it improper. That's not discovery issue. That was remedied and something that the jury needs not to worry about. If you want to ask for questions about the formulation of that opinion and when it was provided, that it wasn't provided at depo, and today may be the first time that it's been provided to you, fine. But we're not going to get into there was a promise and it gets complicated. I'm not going to do that. The objection is sustained. Poor Mr. Owens. All right, what do we got here? Who is maybe Mr. Owens still? And you would agree that's a subset of post-traumatic stress disorder? Answer, yes. And you would agree that Lenore Walker first developed the theory of post-traumatic stress syndrome? Yes. And I think at the time of the deposition, you weren't sure that you knew of Lenore Walker? I don't recall that. All right, look at page 54. Objection, collateral, excuse me, approach. Mr. J, it's collateral impeachment. It's not a material issue. The court, what is this, her knowledge, and what line specifically on 54? Mr. Owens, it starts on 54. I start the question at 23. The court, where is the impeachment at? Mr. Owens, you see on 54, I think Lenore Walker is the one who first developed. The court, she responds, I'm not sure. Mr. Owens, she responds, I'm not sure. I got therapeutic trustees, which is the authority of trustees on battered spouse syndrome. The court, right now we're looking at impeachment. What's the impeachment? Mr. Owens, well, the court, what's the contradiction? Mr. Owens, is that she didn't even recognize who's the authoritative person in the field of battered spouse syndrome, which Dr. Michael Brennan recognized, and I think she spoke of it. I know he spoke of her in his testimony. I think Dr. Harper mentioned Lenore Walker's 3-step cycle for battered spouse syndrome, and she was not even sure who Lenore Walker was. The court, okay, what's the impeachment? Mr. Owens, the impeachment is, I'm going to ask if she recognizes this as authoritative trustees. They spoke on it. She wasn't even sure who Lenore Walker was. The court, what if sustain that as collateral? Mr. J, while we're here, what's becoming obvious to me is that when we started asking about alcohol abuse disorder and narcissistic traits and all the things the state did not get her to opine on, this is essentially like him calling his own witness to impeach, and that's improper impeachment under the evidence code. I can't call a witness just to impeach the witness in front of the jury. This is what he's doing on these new topics. He's bringing these topics up that the state didn't, and they're impeaching her on them, and it's improper. Mr. Owens, Judge, the court, I disagree with impeachment on them, but I'm going to agree with you that this is a collateral matter, and I'm going to sustain the objection. What else we got here? Are we near? Who's smoking a cigarette? Oh, this is a video? Oh, this is a video with Sarah Boone. Maybe it's a body cam video or something. All right, guys, we're in page 2,200 territory. Are we getting to closing arguments, maybe, possibly? Let's see. We are reading text messages on George's phone, possibly. Mom, George, to owner, I'm coming over with the handle. I was helping Pop all day cut grass. Owner to Mom, George, yay you. Getting in the shower, then out. Bye-bye. Mom, George, to owner. Mr. Owens, Judge, can we approach the bench? Yes. Yes, sir. Mr. Owens, this is the problem that I tried to address in the beginning about having someone else reading these text messages. He's changing his tone during the reading the text, which is what I thought he would probably try to do. I object. The court. Anything further? Mr. Owens. No, sir. The court. Overruled. I could have sworn when he read the text messages it was very monotonous. I think it was so monotonous that I decided to read the text messages myself, if I remember correctly. Text messages. Oh, this was like a long one. Okay. Oh, is this when they're reading the Sarah Boone notes? Okay, so guys, this is like a little bit, well, not even a little bit, this is pretty fucking unhinged, but I think we wanted it for context, maybe. This is Sarah Boone writing the notes, I think, in her notes, and I think she's like kind of writing it to George, maybe. Going on through the rest of page 43, page 44, including page 44, dirty, cheat, enjoy your porn, jerking yourself off secretly so your parents don't see, and your ugly new girlfriends. I can't wait to finally be with a real man, Ben, who well and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all well worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow, now you really are. You're despicable. Next text is XOXO from Mo to owner. Page 50, 6/28, 2019, 10:55, 47 p.m. From owner to Mo. Just know, I can do so much more damage than all of you put together. Know that. Oh my gosh. Whenever I hear the phrase just know or know that, I just automatically think of Sarah Boone now. Woo! Going to page 51. Try me. Oh gosh, she's so cringe. Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner, no metadata, but from Janice. Sorry, it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but he was quite bummed out that he overslept. But I was okay. Told him, no problem. Just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered. So I have no idea where he is or what he's doing. What happened last night? He had a black eye. He said it was new because I asked him and he told him put makeup on it. He said he'd taken care of it. Did you two get into it again? He acted like when I told him he had a black eye, at first he didn't know what I was talking about. I guess he kind of just blacked out. You can text me back if you want. 11:30 p.m., 30 seconds from owner to mom George. Janice just called me looking for George and she's pissed. Congrats. Page 82, 8/21, August 21st, 2019. From George to owner. I love you, my friend, my love, my queen, my everything. Your Honor, that concludes everything I'm going to publish to the jury on this exhibit. Mr. Owens. Judge, can we approach the bench? The court. Yes. Yes, sir. Mr. Owens. Judge, I understand they introduced that exhibit as a copy of the exhibit, which was 111 pages, but we didn't know which ones he was going to cherry pick and read to the jury, so there needs to be some kind of instruction that explains what just happened. I'm exhibiting something like out of 108 pages that there were exhibits. The prosecutor elected to read those sections to the jury now. These text messages are not all the ones on the phone. Those with the highlighted have been selected to be read by the state attorney. Something like that. And also, Sarah Boone and George Torres shared that phone, and some of the messages may be George. I don't know, man. Do you guys think some of those messages were George? Those hateful, spiteful messages? Could have been George. Love the blame game here. The court. I'm a little hesitant. You're covering the microphone. I'm a little hesitant to give the second part that George and Miss Boone shared that phone. That's me commenting on evidence. I'm not allowed to do that. Mr. Owens, you agree they shared the phone? Mr. J, I think you're more than welcome to point that out in closing. I think I said it in opening. The court, I'm disinclined to do that. I'm not allowed to comment on the evidence. Mr. Owens, okay. Then I think one of the other instructions we're going to have to ask is that the prosecutor jump pages. He went from 4,324, which is July 26th of 2019. Then he jumped to page 4,336 to August 19th of 2019 as he was reading that. So the jury, I believe, needs to understand all of that. The court, I'm disinclined to identify specific pages. Again, I think it's me commenting on the evidence. I'm not on board with something along the lines of with Exhibit 21, just at 108 pages, or it's everything that's included, including those pictures and everything else, right? Mr. J, it's the videos and the movies as well, which some were published. The court, which was published yesterday. Okay, so what if I had the, something along the lines of, the state has concluded their presentation of State's Exhibit 21. It's not inclusive with everything. The state identified certain portions for you and that the entire exhibit will go back to you in deliberation room for your review. Oh my God, they had the entire exhibit? I wonder if how long did it take to deliberate again? Was it under 5 hours? I wonder if some of those time was just them being nosy and just reading some of the exhibits. I don't know. I feel like I might be like, I want to see this. I want to read this. Damn, they had the whole entire exhibit to go back with them. Mr. Owens, I trust your judgment. Mr. J, it sounds verbatim as to what I said at the beginning. If it needs to be coming from the court, I don't have a problem with that. The court, I don't have a problem saying that. I'll do my best to remember what I just said. Mr. Owens, you want to write it down? The court, I want to write it down because I kind of just spit that off the top of my dome. Mr. Owens, And of course, Sarah Boone wanted me to let the judge know that the context of all the read text messages by the state were not read in their entirety. I think she meant maybe the thread of the text messages. This changes the understanding by not knowing the whole message. I don't know. Them having the whole message doesn't really change the meaning. I know context is everything, but I don't know if it helps her. The state only selected what they wanted you to hear, that it was not complete. Also, she objected by his tone, by the way he was changing understanding. Some were not read properly in the light of manner as they were meant to be sent by the defendant. The cadence, she's saying that he had special cadence between each other and the other way they talked to each other, and he missed by his tone. He was misrepresenting their cadence by him reading those to the jury. The court, I don't see any heightened change in Mr. J's tone as he read the messages. They were read in a flat manner. There was no emphasis on certain words or another. Thought it was read in a benign tone as best as possible. As to the cadence of conversation between Ms. Boone and Mr. Torres, I can't speak to that. I don't know that anybody spoke to that other than Ms. Boone. I don't find any issues with the way in which the state delivered the reading of the instructions. The tone was flat. It was benign. There was no raising and lowering of pitch to add any drama to the text messages that were highlighted. So I'm going to overrule the objection. Mr. Owens, okay. My only suggestion when the jury's out is you can go ahead and announce that so Sarah Boone can hear it. The court, I don't have a problem with that. I'm fine with that. Oh man, Mr. Owens is like, yeah, tell my client. Okay, I tried telling my client that she didn't believe me, so that's why I want you to read it out loud. I feel like that's what happened, you know? I feel like Mr. Owens is letting Sarah Boone being the boss a little bit instead of just dealing with your client on your own. All right, that's fine. Let me go back with the instruction. What about something along the lines of members of the jury, the state showed you portions of State's Exhibit 21. It's not the entire exhibit. The entire exhibit will be sent back to you on the laptop for its review during deliberation. Is that acceptable? Perfect. Yes. Anything else we need to address? No, sir. Anything else, State? No, sir. Thank you.